it to the cloud. Okay, great. Well, thank you for coming. I think this is the very first 6 research seminar for 2024. So I'd like to acknowledge the Wiradjuri, Ngunnawal, Gundungurra and Biripi peoples of Australia, who are the traditional owners and custodians of the lands on which Charles Sturt's campuses are located, and pay respect to their elders, both past and present, and also to the Wurundjeri people of the Kulin Nation, who belong to the land of Naarm, where I live and work. So today we are very lucky to hear from Hamid, who is going to be talking to us about copyright and universities. And Hamid, as you all know, is our fabulous associate professor in the School of Information and Communication Studies. And he researches all sorts of fabulous and interesting things to do with publications and scholarly research. So I'm going to hand over to Hamid and he will talk to us about his research. Thanks, Hamid.
Thanks, Jane. Let me share the screen.
Yep, that's the one.
Yeah. All right. Hello, everyone. Thanks for joining me in this presentation. So I'm going to talk not about copyright, but about intellectual property policies at universities. And I should say that, first, I should say that I have no expertise in intellectual property. It is a big research area under the law and legal studies. And in Australia, actually, there is a, I put it in the chat box. There is a big research institute at the University of Melbourne just for intellectual property studies. And those people, there are a large number of researchers there. They look at intellectual property, not that is in the School of Law, not just from legal perspective, but also from innovation and technology policy and other aspects too. So they do a lot of research if people are interested in actually intellectual property research. I should briefly say why I did this study. We did with Simon, Mariam, and Danny Kingsley. We did a study on open access policies of Australian universities, and we found that a good number of them actually didn't have a policy at all. And the rest of policies, there were lack of clarity, inconsistencies, and issues like that. But open access policy is not like the core to the business of, it is kind of something that is being developed as we, and progress as we move. But IP, you would say that is more critical. I wouldn't expect a university to be able to function nowadays without an IP policy. So I took an interest in research commercialization. I was going to do some more research because it is related to my research area, which is the research impact, kind of. And when I started doing research on research commercialization, I thought that obviously policy plays a big role in research commercialization because that determines what the innovation is and what the researcher gets and what the university gets and what basically the responsibilities of different stakeholders in the process of research commercialization at universities. And I thought the best place for me to start exploring that area would be to do a literature review, which I'm doing. I've done most of it, but also to look at IP policies of university to see what their position is in this area. And at the same time, we know that Australia lags behind in research commercialization at universities. If you compare Australian universities to, for instance, universities in North America, they make a lot of money out of their research commercialization. They are very active in terms of commercializing patents, the spin-offs, and a lot of big companies, tech companies that now, they came out of basically those innovations that started at universities. We're not making a lot of money actually in Australia. I mean, a few big universities, maybe group of 8, but most of universities are not good at this. In North America, they have things like university technology transfer offices, very active in those universities that provide a lot of support for their staff to pursue commercialization of their innovations. We have like university technology transfer offices in some of Australian universities, but we're not as big as them. And statistics says that in the last 5 years, at least, our ranking in the innovation index has been declining. We know that it is a problem acknowledged by the government, and they recently, in the last 2-3 years, they announced a few initiatives to address this. and they still talk about innovation driving and you see it in their narrative now. Two of the initiative was they announced 2.2 billion investment through the University Research Commercialization Action Plan. There was another announcement about $450 million over 10 years investment in medical research commercializations, and so on. So that's why basically I took an interest and I thought I should do some studies. Giving you a bit of background about basically, should remove this, about policy background. Basically, a landmark or something that inspired many countries around the world to start some policy initiatives and legislation in this area was that Bayh-Dole Act in the USA in 1980s. Before that act, what happened that the federal government would fund research in small businesses and universities. They would do, and sometimes that would result in innovation, and then they would hand back the ownership of innovation to the government agencies. The government agencies didn't know what to do with it, so they would warehouse it, and that was a waste of money and innovation because the governments are obviously they're not efficient in making use of those innovation or commercializing. So that act in 1980 allowed American universities to take ownership of IPs that were generated with federal dollar, with federal money. And after that, other countries, they were inspired and they, in 1990s, for instance, there were emerging claims in Australia about IP generated by staff and students. And then ARC, Australian Research Council, and Higher Education Commission Advice on Intellectual Property in 1995 came out, and they recommended that all universities should have IP policy by November 1996. And they also made it a requirement. They said, if you want government money, if you want to receive national public money for research, you need to have a fund. One of the requirements is that you need to have an IP policy, or you need to cover these areas at least in another policy or something. So that is one of the reasons that all universities definitely have, and by 2002, 2001, I think there was a study that confirmed that all universities kind of had IP policies one way or another. And then National Tertiary Education Union, they developed a model IP policy in second part of half of the 1990s. That's not 1990, it is the decade, basically. I should have put an S at the end. And some of the similarities that we will see through the study that I share now is probably because maybe some universities actually followed that model policy that was developed by NTU. There has been not many studies, but there have been a few studies. In Australia, there was only one study, but that was about 25 years ago by Monotti. I think she reviewed IP rights in 30 Australian universities, and she found that, for instance, revenue sharing varied between 30% and 60%. And she looked at a few other things. There was a PhD thesis by Ross in 2021. I think, I don't remember. They looked at who's the responsible decision maker, for instance, identification of innovation, who's responsible for investigation, for initiating the commercialization and so on. And they found that there was a great deal of variation in terms of responsible decision makers in this area at different universities. Most of the studies happened in this area in Canada, I would say. That was the country that they studied IP policies more than any other country, I would say. And they were a mix of findings. Some research found that if you follow university-owned model, for instance, there is a greater yield in terms of revenue. Some other studies found that if you follow creator-owned model, there will be more innovation disclosure. The staff will be more encouraged, they will have more motivation to reveal the IP, to do patent and then disclose it to the university and they say, we have this innovation, we have this patent. So, and a few other studies Europe. So my aim was very descriptive and simple. I wanted to look at all of the policies at Australian universities that were specifically on intellectual property. I wanted to see what intent or purpose they follow, how they define IP, what approach they have to the ownership of IP, and how they distribute the net revenue that might result from commercialization of intellectual property. I picked all of the public universities. I excluded 5 private universities, including Carnegie Mellon, which is an American university. They have a branch here, and other universities for obvious reason, because they have different administration and nature and so on. And I looked at their policy libraries, did some Googling, browse their website, but also there is a World Intellectual Property Organization. They provide a link to, they're not up to date, but they provide a link to most of the IP policies of different universities in different countries. So that was also helpful. I made a copy of all of the policies because they changed. If you start 2 months later, one university might update it. I wanted to look at them at one point in time, so I downloaded all of them in November 2023 and looked at the policy at that point. I used the checklist, but also did some content analysis looking at, for instance, purpose statement and see what themes emerged from those. In terms of dates, they were mostly up to date, with the median being 2 and mean being 3 years old. But there were a couple of policies, like 26 of them had a date for the next review, but in 10 of them, that date was in the past, which means as we know, universities are slow when it comes to these processes. So they were supposed, for instance, to review the policy in 2022, but still they didn't do it. And the longest was 6 years overdue. I looked at the policy owners. Most of them were related to the research portfolio of the university. So the Pro Vice Chancellor or Deputy Vice Chancellor of Research, DVCR, PVCR, but also there were other things that you would say they were not very relevant, like university secretary or I don't know, some other positions. I looked at to whom the policy applied. So there were a lot of them would say to all of the staff or all of the employees, but some of them would use, like a few of them would use terms that you would say they're not very clear, like the policy applies to all of the university members, or it applies to the entire university community, but they wouldn't say what that actually means or who is included in that community or members. I thought, because if you have a policy about IP definition, you would expect the IP to be defined in that policy, because if you don't define it, then you can't go into details of saying, who owns it and so on. So 2 policies actually did not define the IP in the policy. So it is possible that they have defined it somewhere else, but I couldn't see the definition there, and I couldn't see a link to definition somewhere else, which was interesting. 5 defined IP rights, but not the IP itself. But the rest, they had a definitions. When you looked at them, there were some themes. A lot of them took a broad and inclusive definitions. They would talk about registered and unregistered rights and IP types. Some of them took a kind of detailed enumeration approach. They said by IP, we mean, for instance, patent, design, trade secret, know-hows, etc., etc. So they would provide a list of things that they would consider as IP. And there were some distinctions and clarifications, like they would separate moral rights. And one of the policy for one of the university, actually, it was called intellectual property and moral rights policy. But most policies, they would separate moral rights from IP and IP rights. In terms of, so I combined all the text that policies might have about intent, purpose, or objectives, and I did an analysis of, and a few things emerged, like the policies basically aim to clarify ownership. So some policies, they had a short sentence about purpose. They would say the purpose of this policy is just to clarify the ownership, IP ownership. But they had 2 paragraphs of text or at least bullet point in terms of what you're trying to achieve with that policy, and included ownership and compliance. They would say this policy is aimed to support innovation, is supposed to flourish, provide an environment for research and teaching to flourish, it facilitates commercialization and hopefully it will result in or increase the economic impact. It advanced the transmission of knowledge. It is part of, we want to be transparent and it's part of our governance of IP and management principles that we follow. We want to protect the rights. We want to have the community engagement. We want the research that we do at this university to have real world impact. And a few, like two of them only mentioned dispute resolution. They would say this policy also is about how, in the case of dispute, how that is resolved. But that doesn't mean that the rest of the policies actually, I can imagine all universities must have, or definitely they have some information about, in the case of dispute, how they resolve that. But maybe that is not covered in that policy. They might have. Actually, I found that at least in one case, the university had a separate, completely separate document just on dispute resolution, because actually there has been studies on litigation cases when staff sue the university or university sues the staff over IP rights or patents and so on. Ownership of IP by staff. So all universities, generally they say any IP created by a staff is owned by the university. And then they go on and clarify the certain conditions under which the IP is owned by the university. Like they say, IP you create during your employment, if you're using university resources, if you're using a contract research or sponsored research, if you're commissioning you to do some work, whatever IP you create is owned by the university. But they also have a specific exclusion, like they say, if you're writing journal article, scholarly article, if you're not interested in the IP of that, you own the copyright and you own the moral rights and so on. And they have, some of them, they had some room for flexibility, like they would say, we can enter into specific agreement for certain things with the staff that allows a different arrangement, different from what is outlined in this broad policy. In the case of students, it was I would say it was the opposite, and that was also the finding of one of the old review, that they would say the students own the IP, but if the IP is generated under these circumstances, we own the IP, the university owns the IP. Only, I think, one policy mentioned undergraduate student. The rest of the policy, they don't say undergraduate or postgraduate, but the things they talk about mostly apply to postgraduate and students involved in research. And so, as I said, most of them, they say, we don't claim IP for student IP, but certain conditions means that we own. And that is, if a student is working at university, we will treat them as a staff, and therefore IP is owned by the university. If you are using the university resources significantly, we own the IP. If you're part of a research project or a contract or something, then we own the IP. So they have conditions that apply to student work. And this is one of the areas that also research has shown, and my study found that there can be better clarity. Like they have clauses, like they would say, if you're making significant use of university resources, the IP belongs to university. But that is open to interpretation, because what is significant use, that they don't define that. So it is a bit subjective to determine that. And by visitors, I looked for visitors, they said in 10 policies, no mention at all. Some in 6 policies, they said that the ownership of IP created by visitors will be determined by the agreement they sign before actually they come to the university as a visitor. And 11 policies, they have, in legal terms, they call it presumptive inclusion, which means they say we own everything visitors create, and then they go on and say list conditions under which they don't own. And 4, they had presumptive exclusion, which means they say, no, we don't own with the IP created by visitors unless X, Y, Z, and those are like, if you're using our resources, if you're part of a bigger project in collaboration with our staff, and so on. I also looked at affiliates, like search different terms like affiliates, adjuncts, honorary appointees, title holders, associates, and so on. 7 policies had no mention. 6 included them as part of the staff. 5 included them in the visitor category. And the approach was similar to what you see in visitor. So some would say we own everything, and then list the condition, certain circumstances that they don't own. And some would say we don't own, but if you're involved in this and that, we own. When it comes to indigenous cultural and intellectual property, so 11 policies had no information in that specific policy, but I can imagine this doesn't mean that that university doesn't have anything in relation to this. It might be that they have another document in relation to indigenous cultural and intellectual property, because I can imagine this is too important for universities to have it vague or have no formal policy or stance in relation. But in that specific policy, intellectual property policies, in 11 cases, there was no information. And for the rest, they either had a section specific on ICIP, or they had statements in relation to this in the policy. And when I analyzed the text of when I did the content analysis of the text in that part, it was so a few themes emerged. Obviously, recognition and respect. They would explicitly acknowledge the significance of ICIP. They would talk about ownership and consent, very, very clear stance against asserting ownership over intellectual property related to indigenous culture and IP. They talked about we comply with the standards and ethics when it comes to this, whether that is national or international and Australian legislation. They talked about benefit sharing. They said, like, based on the pre-agreed terms, we would make sure that there is a fair distribution of the revenue between the stakeholders and the university. And they talked about the consultation and negotiation process that would will happen when indigenous IP is involved. But I thought that this was, and given that 11 policies had nothing, this was another area that policies could improve. An important part of IP policies that influence actually academics' behavior, their innovation behavior, is how the revenue is shared. So if you have a patent and that patent is commercialized and some money is generated, so how do universities share that? And so this was specified in 24 of them. For the rest, they did not have, but I thought that it's impossible for universities not to have anything about this. So I went and looked at, because some universities, obviously, policy and procedure could be separate, and in many cases are. So I looked at, in the case of those other universities, looked at procedures or try to find some other document that outline how they distribute the revenue. In 9 universities, I found that they had that information in this procedure document, but in the case of 4 universities, couldn't find any publicly available information about that. It might be possible that they have a document that is not publicly shared, which is very likely. And when I looked at that, so basically the creator's share of the net revenue ranges between 1/3 and 1/2. So between 33% to 50%, depending on different universities. But the average is about 42%. That is what so if money is generated, 42% goes to the creator, the rest the university take, and they distribute it in different ways. Some universities had a tiered system, like they would say, first $100,000 all goes to the creator. Anything above $100,000 revenue, we will take 30%, the creator takes 30%, and so on and so forth. And some policies were clearer in terms of how the university share is divided. So if you look at this document, you can see the Word document. So this is the detail of how they share the revenue. You can see that, like the ANU says, the first $50,000 all goes to the creator. We don't take anything. But above that, 50% goes to the creator, 50% goes to the university. And that 50%, some universities are clear in terms of what they do with their share. Like you can see in the case of Central Queensland University, they give 40% to creator and they take 60%, but that 60%, 20% goes to the unit where the staff is located, staff that was the creator or innovator is located, like the school, for instance. And then the research division takes another 20%, and 20% goes to the central, basically the university, and the purpose is that basically that unit and the research division, they will reinvest that money into research facility and supporting staff and so on. So some of them you can see that they are vague. They say 50% the university takes, and they don't say what they do with it or how they distribute it internally. But some of the universities are they have more information in terms of how they divide it internally. Some, as I said, they have tiered approach, like they would say the first 50K, first 100,000K, as you see here. They give to the creator and they take the rest. Some, they have a flat rate. They say 50%, 50%, or a third to the creator and 2/3 to university. So, conclusion, obviously, in Australia, we have the predominant model is university-owned model, which means the university owns the IP of the staff and students in most cases. But it's not clear whether that is the best approach. Like there was a study at the University of Toronto that they found that if you shift to creator-owned model, which means the ownership of the IP reside with the creator and the generator of the IP, not the university, you will have more patent, you will have more innovation disclosure. And some universities, like the University of Waterloo in Canada, actually they have made that shift and they have seen some positive results. But research in this area is not very conclusive, so you can't firmly say that which model results in greater yield or greater innovation. In the last 25 years, if I compare my study with the study was done in 1999, there haven't been much change. One of the change was that the range of net revenue for the share for creator has narrowed down a little bit. In the past, it was 30% to 60%. Now the maximum you could see was 50%, and the minimum was a third. In some area, like indigenous IP, like student IP, I think there is room for clarity. There are things that is open to interpretation, or there are things that they do not clarify or determine in policies. There were a great deal of similarities between policies, but also, and this might not be necessarily in the IP area, but there were some differences because of the structure of the IP policy documents at universities. Some, they have very broad, high-level policies, and some of those they were like mix of policy and procedures. So they would go into details of dispute resolution, details of who's responsible for identification and initiation of commercialization. But this is probably the different approaches that universities have in terms of where they specify what. For instance, they might have different detailed procedure documents and a very broad high-level policy document that outlines the basic but doesn't go into details. And obviously, the next step would be for somebody to do an analysis of the impact of these policies, whether that is through talking to a staff to see how much awareness exists, but also how these distribution, the way the arrangement they have for distribution of the net revenue influence the innovation behavior or disclosure behavior and so on. I think that's all. There are a few references. So that's the Monotti is the study that a similar study was done in 1999, and a couple of other studies. Yeah.
Great. Thank you so much, Hamid. Does anybody have any questions?
Hamid, I've got a couple of questions for you. Is that okay?
Yeah, sure.
So the first one is Charles Sturt's policy. Was there anything in there that you thought, oh, that's different compared to the other universities? And maybe, I don't know if you can answer that without getting in trouble or not. And secondly, was there anything in the policies you found that mentioned or referenced the university's other information policies like research data management, privacy, information security? Were they mentioned at all in any of the IP policies, cross-referenced?
Yeah, so the first one, I mean, CSU was included in my analysis, but I didn't look. So from top of my head, I can't say what I found in terms of CSU. But I have to go back to it to see if there was anything specific about CSU. So I can't answer the first one now, but I can get back to you. I can go look and get back to you if you want. The second one, yes, there was like data management. I think in the case of two policies, it was mentioned in, I don't remember, it was in the intent. So they said this is also related to that. But also these policies have cross-reference to some other things. Like, as I said, there is moral right. Some policies they included in this, in this. Some they had different documents. The copyright obviously is linked to this, so there were cross-reference between this and copyright, because that's another matter. Like, as I said, some policies in this context, they will say, we're not interested in the scholarly work, so you keep the right for book and journal paper and so on. And they would link you to, for instance. But the other set of documents, and I look for this, that universities have procedures for commercializations. Because as I said, these policies are broad level, and you would expect that if a staff like has a patent, they need to know what is the process for registering that patent, what support they get from the university, and then who approaches a company, for instance, if they want to commercialize it, who does the negotiation. There is a very detailed and long process involved for commercialization. And as I said, some universities have that technology transfer office that they provide that type of support in terms of legal advice, but they might actually take charge on in the university policy, in the North American, actually, there is separate between who is the initiator of the commercialization. So they will say, if we, as the university, commercialize, this is how we distribute. This is what we get, this is what you get. If you, as the creator, commercialize, that situation would change, would be different, and you would get different thing, or a university would get a different thing. I couldn't see that in Australian policies. It was all like, if it is commercialized, this is the percentage you get, and this is the percentage we get. But it wasn't about who is doing the commercializing, who initiated.
Okay, thank you. And just another quick follow-up. You mentioned there'd been a lot of research done in Canada. Is any reason why Canada is sort of producing more research on this IP topic than anyone else?
Yeah, so maybe because of some changes. Sometimes it is because of, like, there is a few researchers who are leading, and therefore they are PhD students. Like in Australia, I could see there were 2-3 PhD theses on this topic, not specific on policy, but they were related to this. And when I looked at that, they like that research institute in Melbourne. So they obviously they are a driving force in terms of researching this. So I think reason might be that there are a few staff researchers who are active, but also there have been changes. Like, you could see that obviously they've done studies, they've made recommendations, changes happened, and now they are interested to see, like, that narrative about maybe we should shift to creator-owned model rather than university-owned model. That it is coming mostly out of Canada, based on the studies from Toronto and Waterloo and other places.
Okay, thank you.
Annie, have you got your
Yeah.
real hand up? Yeah.
Hi, can you hear me, Hamid?
Yes.
I haven't got my settings quite right on Zoom, as you can see. So I don't really understand how IP intersects with copyright. I mean, it's not a sort of complete subset of copyright's not a complete subset of IP, is it? I'm just a bit unclear.
Yeah, so I would say so. So intellectual property obviously is a broad category. It covers like trademarks, it covers patents, it covers copyright. But these IPs are more related to commercialization. And because they want to facilitate that, they're not I mean, IP of what I write, for instance, for my subject belongs to the university, so to the copyright. So if I write like a module for one of my subjects, the copyright belongs to the university, but I have some moral rights over it. So there are different rights involved in this area that universities separate. Like they have to respect my moral right even when it comes to the like a patent. So they will be recognized as the innovator and all of that. But if they go ahead and commercialize it and make some money out of it, these policies are about what's going to happen. And one of the reasons they have, because they want to minimize litigation. They don't want to go into legal cases. And research actually has shown that it's not a good avenue if, suing a staff or staff suing is not a good thing. So they want to minimize that dispute between different stakeholders. Why do most of universities do not have IP policies on indigenous? So it wasn't most, I said 10 of them, there was nothing in this particular policy. As I said, I can't say they don't have policy on this. In a few cases I looked, I couldn't see much, but again, not everything is publicly shared. Like in the case of one or two of the universities, I actually had to email them and say, because I found some document. When I went through the normal avenue, I faced password protected. So I clicked on the link of policy, but then it would ask me to log in. So I had to email them and say, I found this public document. Is this your latest policy and so on? So now not every policy and procedure is publicly shared, especially procedure documents, because that is about how they do things rather than their stance again for things. So I'm guessing that it is very likely that they have something else, but they haven't covered it in this specific policy. So I can't say that they lack a position or they don't have a position when it comes to ICIP, indigenous intellectual property. But all I can say is that in their intellectual property, there was nothing about in this area. So that's all. Tina.
Yes, thanks, Hamid. I think this is a very interesting topic. What's your next step about this research? And now currently you go through the documentation analysis. So what's the next step and what's the implications you want to generate for guiding the research commercialization at university?
Yeah, as I said, I was interested to move into this area and do a bit of exploration. So in conjunction with this, I've done a review of all research related to Australia in terms of research in the area of research commercialization and technology transfer. So I need to finalize that and see, because some issues I can imagine will come out of that in terms of what is the problem, why we are lagging behind, and whether that relates to policy or whether that relates to how universities are functioning here, or what type of support we are providing to the staff, and so on. So once I've completed the review, I would have a better idea in terms of where the problems might be, and then I can look into, for instance, because it's not, I can't claim that there has been actually ARC even some years ago about case studies in terms of how best universities can commercialize research. I can imagine there are definitely problems because, as I said, one research showed that we are spending more money on university R&D compared to some other similar advanced economies, but we're not getting enough commercialization out of it. So it's not a matter of just investment. We are putting a lot of money, but we're not doing this. The performance is not the same as you get, for instance, in the case of Hamid. So might be, in the literature, they talk about entrepreneurial university and entrepreneurial staff and so on. So, and there is a rich body of literature, I would say. So it might be academic culture, you know, the way we academics approach our work and how the worldview that we have, expectation we have from ourselves. It might be the support. It might be, I mean, I can imagine it can be a combination of all of these, the policy and the incentive and the support and the training that we have, and all of those might contribute to this.
Yeah, that's right. And also, you know, the enterprises, the culture, you know, some universities are trying to promote. And also the engagement with the industry partners and or we're doing also the research orientation, like the industry significance research, etc. That's a lot of relevant, interesting issues.
Yes.
Definitely.
Hamid, did you find any differences in any of the policies about the treatment of different types of staff, so professional staff versus academic staff, or are they all given the same?
No, so they would say staff employee. So that's the most common term was this policy applies to all of the employee or all of the staff.
Yeah, interesting.
So they don't say that like professional staff or academic staff. So if you're doing work for university, that's what they care. If you're employed by university and you're doing, and your IP is generated as a result of your work, that belongs to the university.
Mm.
And they also include other categories, like as I said, in many policies they will say affiliates are staff or visitors are staff, and whatever rule we apply to staff, apply to them as well.
Interesting. I reckon it'd be really interesting to look at the impact of having creator-owned models in terms of staff mobility. So I think if you owned the IP of this thing that you've created and it was commercialized and profitable, I think you would be a very high flight risk to leaving that university and going and being employed by some corporation.
I can imagine there are things like in some of the policies, one of the like conditions when they say we own the IP, like in the case of a student and staff, is that if you created an innovation in which you use some other IP that we already had, we have some claim over that as well.
Okay, so it's not fully owned by the creator.
Yeah, so if you, like in the case you are describing, if I create a work, if a staff member comes up with some innovation here as part of their employment, and so some of those might be some of those legal cases, and then you move to another university or you move out and then start, and the university finds out that this was the outcome of your research here, but you're commercializing the outside, they will sue you. And I can imagine some of those cases are probably like these, because if you see that, you know, there is a lot of money in this and then you want to say goodbye and go and create your own company or something.
That's right.
Yeah.
Okay, great. Well, are there any other questions? No?
I like the idea of flight risk, Jane. That makes it sound like you need ankle bracelets or something.
Yeah, so that's harking back to my research. Right, well, thank you so much, Hamid. That was really very interesting, and I wish you all the best with your research and getting that published. Thanks for everyone for coming along. This has been recorded and will go up on the school YouTube site. It'll be embargoed for a little while out to the public because Hamid is working through the review process of getting this published, but eventually it'll become public as well. So thank you so much for coming.
Thanks, everyone.
And we'll be back next month with Rachel Walls talking about her PhD work. Thanks, everyone.
Bye, everyone. Have a good evening. Afternoon, sorry. Bye.
Bye. It's hot, isn't it?
Yeah.